verify the address based on the law cannot stand. The application, therefore, by the state to have the matter postponed to 25 November for verification of address is found to be light on the scale of justice and is therefore dismissed.
Please, Your Worship.
As it pleases the court, Your Worship, the state accepts the ruling of the court. The 8th of November. I think regarding the address itself, I'm definitely going to attend to that in the bail application for accused number 9. And then the court might revisit or just take that into consideration. The 8th of November for bail application for accused number 1. Your Worship, may I then request that the matter of accused number 1 also stands down, as he already has a date of the 8th of November and 2024 to return to this court for a bail application.
You mean not to stand down but be postponed?
To be remanded, yes, until the 8th of November, as it pleases the court.
Mr. Court, please, if I may just quickly approach the accused before I address the court. Thank you, Your Worship. First,
Thank you.
This court pleases, Your Worship. Before I address the court with the instructions from my client, I firstly agree to the postponement to the 8th, then like my learned friend said. The other aspect is accused number 1 would like to remain in court and listen to the bail applications that is being brought today.
Granted.
As court pleases, Your Worship. Then what he wants me to place on record is, and this is his instructions, obviously I was not there, I'm not privy to this. He has some concerns of things that is happening to him specifically at the prison where he's being kept.
That is a bit premature. I'd rather listen to that after, when the matter is being postponed and a determination of where he is to be kept is to be made. At this stage, he's going to be sitting and listening to the other application. That's premature.
As court pleases, Your Worship. I understand. We will address court at a later stage then on that. As court pleases.
Thank you. Mr. Conradi?
Your Worship, that will bring us then, firstly, we'll do the bail application for accused number 3.
Yes.
Your Worship, sorry for me interrupting at this stage. I know it's extremely rude from me. The
So why do you do it? It's all right.
Well, I'm going to ask the court to permit me to do it. Your Worship, the situation is that, as the court heard this morning, that 4 additional charges has been added to the charge sheet. The charge sheet has not been made available to accused number 9 as yet. And may I ask that during the proceedings, that till we get to accused number 9's bail application, that the state try to make a copy of the charge sheet and hand it over to accused number 9.
That can be arranged, Your Worship.
Yeah, but perhaps you can take your seat for a moment.
Thank you, Worship.
Mr. Conradi, an earlier indication to the court was that there will be 4 bail applications that are brought today.
Yes.
That is accused number 3,
Your Worship, it's 3, 5,
5, 6,
6,
and
and 7.
And 7.
Yes, those 4 applications will not be opposed by the state, but then accused number 9 is also bringing an application today which is opposed by the state.
Yes.
So there's 5 bail applications there.
All right. Are you ready to proceed? I see the gentleman for the accused is ready already.
I am ready to proceed with number 3, Your Worship.
With number 3.
Yes.
Very well. Thank you.
As it pleases the court.
It was already, you were not here previously.
No, I was not, Your Worship.
It was already indicated, I'm just saying this so that you are bringing you up to speed. It was already indicated and it was at idem, but the defense was at idem that this is a Schedule 5, the offences for which the accused are appearing before this court are under Schedule 5.
Understood, Your Worship.
And are you also in agreement with that?
Your Worship, at this stage I am. Of course, I haven't had sight of the updated charge sheet after the charges which was brought this morning, or the charges added, but I am in agreement that it is a Schedule 5 offence and the proceeding should follow that.
Very well. Thank you. Proceed.
Thank you, Your Worship. Your Worship, as discussed.
Is that now for accused number 3?
Yes, Your Worship.
Just for the record, shall the accused number 3 stand? Thank you. Sit again.
Thank you, Worship. As discussed, I am on record for both the accused number 3 and number 6. Their formal bail applications will follow a very similar suit, as they are husband and wife and living together, as the affidavit would set out. Your Worship, so to that extent, I have extensively consulted with the parties involved, and I have prepared an affidavit in support of a formal bail application. Your Worship, at this stage, I would request to proceed to read it into the record before making further submissions. Your Worship, I do have a signed copy thereof, and I beg leave to hand it up prior to reading in, or shall I first read in?
If you give me a copy, would you be remaining with another?
I've made sufficient copies that there's one for Your Worship, there's one for myself, and there's one for my learned colleague, but they have been supplied with a copy of same. Your Worship, can I just get confirmation from my learned colleague whether he needs a printed copy?
I do have a copy of it. Well, can we have another one, please?
Thank you. Proceed.
Thank you, Your Worship. Your Worship, the affidavit reads as follows. I, the undersigned, Johannes Jacobus Badenhorst, with ID number 83040150158082, do hereby make oath and state the following. I'm an adult male South African citizen with ID number A304015015082, currently 41 years of age, residing at 24 Longtom Avenue, Ifafi, Hartbeespoort, Northwest Province, South Africa, and the applicant in this application. I'm the owner of this property and reside here full-time. And Your Worship, a formal deed search has been annexed to the back of the bundle. Your Worship, at this stage, I would just like to refer Your Worship to essentially page 8 of the bundle, which is a database property earth search as done from Searchworks on the 30th of October of this year, which sets out the property details. It sets out that the registration took place during the 25th of August 2022. Your Worship, so he has owned this property for a for a lengthy period of time. And at the bottom of that page, it does confirm that Mr. Badenhorst is indeed one of 2 owners of this fixed property. Your Worship would also note that on the following section, his wife is the second owner, so they are the outright owners of this property. Your Worship, then I'll proceed on page 2. I confirm that my wife, being a co-accused, lives here with myself. This affidavit is in support of an application for my release on bail pending the finalization of the investigation and subsequent trial under the above case number. In the personal circumstances, I have 3 minor children, of which all 3 reside with myself and my wife at the above address. For the foreseeable future, our complete family will remain in this address, and both my wife and I will actively be seeking work in the area. I have the following important family ties within the Republic of South Africa: my 3 sons, my parents, my in-law parents, and extended family. I will not abandon my family and my family obligations by fleeing from them. Paragraph 4, historic antisocial behavior. I have no previous convictions and have no pending matters against me other than this, of course. Travel documents and international ties. I do possess a valid South African passport, which has already been handed over to the South African Police Services. I do have family in Australia, however I've never visited them before. I do not intend on travelling abroad in the foreseeable future. I have no assets outside of the Republic of South Africa. My finances are of such a state that I cannot afford a large sum for bail money, as I currently maintain my children residing with myself together with my wife. I'm also currently unemployed and actively seeking employment as I'm a qualified millwright. I have already attended interviews prior to my arrest. Dealing with assets and financial position. Other than the fixed property referred to above, I do not own further significant assets, nor do I have significant cash reserves, and I will have to work to generate an income as set out herein. Intended plea. Presently, I do not have formal detail about the state's case against me, and specifically the strength of the case against me. Insofar as I'm aware, the charge sheet has not been finalized, and I will request full details once appropriate and available to do so. At this junction, I intend to plead not guilty against the charges brought against me. Of legal framework for bail. I'm advised that the relevant considerations that the Honourable Court has regard to when exercising its discretion to what the interests of justice would require is set out as Section 64 of the Criminal Procedure Act, and that I have to prove that there exist exceptional circumstances justifying my release on bail, and I will therefore submit the following. 64A. If the court grants me bail, I will not endanger the safety of the public, any person, and I will not disturb the order or undermine the public peace or security. I have not threatened or intimidated anyone, nor do I intend to do so. I do not bear any grudge against anybody, and I am not prone towards violence. B. I will not attempt to evade any proceedings. I will make myself available and attend each and every court date until the conclusion of the trial. I have no desire to forfeit all that I have worked for and to become a fugitive of the criminal justice system. C. If the court grants me bail, I will not attempt to influence or intimidate witnesses or to conceal or destroy any evidence, nor will I in any way attempt to disturb the police investigation. I'm not an influential individual nor a public figure. I do not intend, nor do I have the ability to influence the case against me, nor the public influence the case against me, nor the public. nor do I know who the witnesses are that may be called against me. Should the identity of these witnesses become known to me, I will refrain from having any contact with such witness. I will furthermore submit to any conditions the court may grant in this regard. D. I will not do anything to undermine nor jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. I will further not destroy nor contaminate any evidence in the matter. I have furthermore given my full cooperation to the complainant and the liquidators in the investigation of the civil matter, and I intend on cooperating to the best of my ability. E. I will not do anything that will in any way disturb the public order or undermine the public peace or security, nor will my release on bail cause such effects. I confirm that at no stage did I give any false information, and at all material times during my arrest I gave my full cooperation. My release on bail will be in the interest of justice for the reasons as set out above, as well as for the following reasons set out here below. If I'm detained and kept in custody, I will be prejudiced, I will lose my ability to generate an income and the means to provide for myself and my dependents. I will furthermore not be able to maintain the household and pay its day-to-day expenses. Under the circumstances, with due consideration of the obligations, if the court grants me bail, I will be able to pay 20,000 Rand towards my bail money. It will be in the interest of justice that I am released on bail. Your Worship, that is in line with my instructions. The accused before this court has had sight of the statement, and the version before Your Worship is fully signed and commissioned. Your Worship, I fully understand that it is not up to an accused to dictate the amount of bail which
we will. That is the second leg of the consideration, Mr. Jordan. We
Yes,
will
Your
get to that as if it is necessary. I don't know. We don't know whether it will be necessary to go to that point. But let us limit ourselves to this stage for now.
Thank you, Worship.
Thank you. Mr. Badenhorst, you may stand. You have signed the statement that's been read out, commissioned as well. You confirm it is yours. The signature appearing, it is your signature. Okay, we accept this as Exhibit G. You may sit. Thank you. Proceed. That will then be for number, unless there's additional evidence for accused number 3.
Your Worship, safe to confirm that the amount in respect of bail needs to be considered.
No.
In line.
I have not made a ruling whether he qualifies on bail. If he qualifies on bail, then we'll consider the amount. But for now, let us limit ourselves to whether he should be released on bail or not.
As it pleases the court, Your Worship.
Any evidence additional to this affidavit?
Your Worship, no further evidence at this stage.
And in relation to the 6th accused?
Your Worship, I have prepared a similar statement for the 6th accused. But what I wanted to state in respect of this accused and the 6th accused, Your Worship would note that from the statement, they confirm the address to one another, that both is indeed residing there. I do also believe that the address was confirmed by the state, and that the address is not in
Mr.
dispute.
Jordan, sorry, I mean not to be disruptive to your addressing me. At this, there will be plenty of time,
Of course,
and trust
Your
me,
Worship, yeah.
to thoroughly ventilate and present arguments. But for now, all I'm interested in is whether there is additional evidence. In relation to accused number 3, there's not. In relation to accused number 6?
Your Worship, in respect of accused number 6 and where the statements differ are purely in respect of the position of employment. The
Yes,
accused number 6.
where's that statement?
Your Worship, I beg leave to hand it up.
Rather an
Your Worship,
affidavit.
I'm sorry to interrupt. May I suggest that we finalize accused number 3, then move to number 5, and then we go to number 6. I think for the record purposes, we can do it in that specific order as the accused persons are numbered. It will just reflect much better, Your Worship. The state is in possession of different affidavits as well. So
yes, I have considered what you say, Miss. In my mind, I did not verbalize it, but I do not want him to stand, sit, and say, because he represents two of those people.
No problem. Thank you,
So
Worship.
that is the reason I'm letting him continue.
Thank you,
Appreciated, Your Worship. Your Worship, I have prepared a similar statement in respect of accused number 6. I beg leave to hand same up. It has been sent to my learned colleague. I've also got a hard copy for him.
Can I have the hard copy, please?
Thank you. Thank you. Proceed.
Thank you, Worship.
Accused number 6, that will be Christelle Badenos.
That's
Stand
correct.
for the record, please. Thank you. Be seated.
Your Worship, I also confirm my appearance on behalf of this accused. Your Worship, as previously addressed, I have also prepared the statement on behalf of the accused. She has had sight thereof, and the version before the Honourable Court is signed and commissioned as such. Your Worship, I will proceed to read the statement into record. Thank you, Your Worship. I, the undersigned, Christelle Badenhorst, ID number 8205-100229084, do hereby make oath and state the following. I'm an adult female South African citizen with ID number 8205-100229084, currently 42 years of age, residing at 24 Longtom Avenue, Ifafi, Hartbeespoort, Northwest, South Africa, and the applicant in this application. I reside full-time on this property together with my husband, with whom I co-own the property. Your Worship, I once again attach the deeds report. Shall I refer the Honourable Court to same at this stage, or can we deem it as canvassed in the previous affidavit?
Deem it as canvassed.
Thank you, Worship. If I may refer Your Worship to what would be essentially the page 8 of the bundle. It is the Deeds Office search dated 30 October 2024 with the property information as set out above the Pretoria Earth Ifafi. Your Worship, at the bottom of that page, Your Worship would note, mid-page, Your Worship would note that the registration took place during August of 2022, specifically the 25th. The bottom would note first owner is Badenhorst Johannes Jacobus. Second owner is Badenhorst Christelle. And then, of course, at the bottom of that section also states the title deed with the title deed number ending in 2022, reflecting that's when transfer of the property took place, Your Worship. If Your Worship has cognition of the next page thereafter, this is a Deeds Office person search, and it just records the same property is indeed registered in her name. Your Worship would also note that it's called in the Deeds Office person towards the bottom quarter of the page, purchase date of this property was May 2022 with registration August 2022. So once again, it's a property that's been owned for a significant amount of time, Your Worship. My husband, with whom I co-own the property, as per the deed search. I confirm that my husband, being a co-accused, lives here with myself. This affidavit is made in support of an application for my release on bail pending the finalization of the investigation and subsequent trial under the above case number. Personal circumstances. available and attend each and every court date until the conclusion of the trial. I have no desire to forfeit all that I have worked for and to become a fugitive of the criminal justice system. C. If the court grants me bail, I will not attempt to influence or intimidate witnesses against me. Should the identity of these witnesses become known to me, I will refrain from having contact with any such witness. I will furthermore submit to any conditions the court may grant in this regard. D. I will not do anything to undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. I will not destroy nor contaminate any evidence in the matter. I have further given my full cooperation to the complainant and the liquidators in their investigation of the civil matters and intend on cooperating to the best of my ability. E. I will not do anything that will in any way disturb the public order or undermine the public peace or security, nor will my release on bail cause such effects. I confirm that at no stage did I give any false information, and at all material times during my arrest I gave my full cooperation. My release on bail will be in the interest of justice for the reasons as set out above, and for the following reasons set out here below. If I'm detained and kept in custody, I will be prejudiced, lose my ability to generate an income and the means to provide for myself and my dependents. I will furthermore not be able to maintain the household and pay its day-to-day expenses. Under the circumstances, with due consideration of the obligations, if the court grants me bail, I will only be able to pay 20,000 Rand towards my bail money. It will be in the best interest of justice that I am released on bail. Thank you, Worship. That is the statement from the accused.
You may stand. The statement that's just been read out, you confirm that it is yours. Can you speak up, please? And it is your signature appearing here.
Yes, it is.
Very well, you may sit. It is accepted, marked as Exhibit H.
Sorry, Your Worship. H.
H. Do proceed.
Thank you, Worship. Your Worship, at this stage, save for the argument in respect of the social justice element as well as the amount, Your Worship, that is the evidence from the accused.
Thank you.
Thank you, Worship.
For accused number 5, Stradom. You may stand, Stradom.
Please, Your Worship, I do confirm my appearance on behalf of accused number 5.
Mr. Shaw.
That is correct, sir, Your Worship, Mr. Shaw.
Thank you. You may sit, Mr. Strado.
Your Worship, I have also prepared an affidavit in respect of accused number 5's application. Your Worship, I do have a copy available for the court. This is the signed and commissioned version, if I may beg leave to hand same up to the court. Your Worship, I have also prepared and provided a copy to my learned friends for the state.
Thank you.
Bishop, I beg leave to read the affidavit into record.
Do proceed.
I, the undersigned, Adrian Dierwald Stradom, identity number 89050150190088, do hereby make oath and state as follows. I am an adult male South African citizen and I am 35 years of age. I am the applicant in this application in which I seek relief from this honourable court to be released on bail. I respectfully submit, as I will demonstrate herein, that the interests of justice permit my release on bail. In any event, the dictates of fairness and justice, in view of the particular facts herein, warrant that I should not be deprived of my liberty and that I should be released on bail. I make this affidavit of my own free will and have not in any way been unduly influenced to depose hereto. The facts herein contained, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. Application in terms of Section 60 sub 11 of Act 51 of 1977. The purposes of this affidavit is to provide the above Honourable Court with my personal circumstances and to address the allegations levelled against me insofar as they are known, as well as to address the facts to be considered by the above Honourable Court as contained in Section 60 sub 4 to Section 60 sub 9 of the Act. I have been advised and I understand that I bear the burden to demonstrate that the interests of justice permit my release and that I am obliged to initiate this application. I will put factors before the Honourable Court to show that it is not contrary to the interests of justice to permit my release on bail. Personal circumstances, address. I currently reside at house number 1, Cornelia Road, plot 6, Leoka Villa, Zandfontein. The property is owned by my mother, Miss Marina Estelle Vandenberg, and I have been residing at this address since the 24th of April 2023. I reside at the property with my wife, Michaela Stradham, and our 2 minor children. I was arrested at my residence and the state has had sufficient time to verify the address or alternatively to inform my legal counsel should there have been a discontent to any aspect of the verification thereof. Employment history. I am currently self-employed and own a restaurant called Brew Brewing, situated in Millennium Park, Pretoria West. I started this business in February 2023. My previous employment history can be summarized as follows. After my studies, I worked at Auto-Equip Tires as a salesman during the period 2007 to 2009, earning approximately 8,000 Rand per month. During the period 2009 to 2015, I was employed at iInstall, an audio-visual company, as a technician, earning approximately 10,000 Rand per month. During the period 2015 to 2017, I was self-employed, having started a company called Link and Install in Pretoria, installing DSTV and camera systems, earning approximately 15,000 Rand per month. During the period 2017 to 2018, I was employed by Maha in Roodepoort as a technician in the calibration of roadworthy machines, earning approximately 18,000 Rand per month. In August 2018, my wife and I secured employment at the British International School, Duhok, in Iraq. I was employed in the IT department, earning approximately $2,000 US dollars per month. We returned to South Africa prior to the COVID-19 lockdown in March 2020. I was unemployed until the end of 2021 when I secured employment at Forever Diamonds and Gold, installing cameras in the IT department. I performed this job and various administrative tasks during my period of employment. I earned approximately 20,000 Rand per month. I resigned in January 2023. Although I am self-employed and own the restaurant mentioned above, I do not draw a monthly salary from the business. The business is new with substantial running costs. The monthly turnover of the business fluctuates between 100,000 to 200,000. At this point, the business is not profitable given the running costs. Furthermore, when I started the business, I secured a loan from Capitec Bank in the amount of 380,000, which I am required to repay on a monthly basis. Our household is run on the income earned by my wife as a teacher. Occasionally, I will purchase groceries for the household through my business. My business employs 6 permanent employees and an additional 6 to 7 temporary employees. Historical personal background. I have no previous convictions or pending cases against me, and I have been advised of the consequences of my failure to do so. I was born on the 1st of May 1989 in Pretoria, Gauteng. Save for the year and a half in Iraq, I have resided in the Republic of South Africa, and specifically Pretoria, since birth, and I currently do not have any family ties outside of the borders of the Republic. I'm married to Michaela Stradham since 2016. We have 2 minor children born of our marriage, a boy aged 5 and a girl aged 2. I have another minor child, a girl aged 13, born of a previous relationship. I pay maintenance in respect of my eldest minor daughter on a monthly basis. I am responsible for her school fees, medical aid, and a monthly monetary contribution of 800 Rand. However, I was awarded full custody of my eldest daughter in February 2024. From 10 October 2024 until 17 November 2024, she will be residing with her biological mother as a trial period prior to us returning to the Pretoria Magistrates Court for a ruling on the matter. My wife is employed as a grade 10 teacher at HTS Pretoria Tainer, and she earns a monthly income of 15,000. I do not own any immovable property within the borders of the Republic of South Africa, nor do I own any immovable property in another country. I own a 2007 Daihatsu Syrian motor vehicle valued at approximately 40,000 Rand. I also own a trailer valued at approximately 30,000 Rand and household items and furniture valued at approximately 75,000. I was arrested at my residence in Pretoria on the 23rd of October 2024 by members of the South African Police Service. The ultimate purpose of my application is to illustrate that I do not present a flight risk, have abided by the sovereign laws of the Republic of South Africa, and to demonstrate to the above Honourable Court that I am indeed a suitable candidate for bail. I vehemently deny the allegations levelled against me in toto. I have been in custody since my arrest on the 23rd of October 2024. I draw this Honourable Court's attention to the case of S.V. Atchison, 1991, Volume 2, SA 805, where Mohammed A.J., as he was then, emphasised that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to the accused unless this is likely to prejudice the ends of justice. I respectfully submit that my release on bail will not prejudice the ends of justice. I am fully committed to attending every date appointed by this Honourable Court. Moreover, if I am not afforded the opportunity of being released on bail, I stand to suffer grave prejudice, which will further impact the security of my employment and my family. In the case of S.V. Branco 2002, Volume 1, SACR at 531, the court held, a court should always consider suitable conditions as an alternative to the denial of bail. Conversely, where no consideration is given to the application of suitable conditions as an alternative to incarceration, this may lead to a failure to exercise the proper discretion. I plead with this Honourable Court to consider alternative conditions to incarceration. Merits. My legal representative has explained the provisions of Section 60 sub 11 of the Act to me. I respectfully make the following submissions hereunder in this regard. I concede that the matter with which I currently stand accused would, in terms of the Criminal Procedure Act, resort under Schedule 5. I intend to plead not guilty to the charges. I am advised that I have the constitutional right to remain silent, and given the fact that the full content of the allegations have not yet been disclosed to either me or my legal representative, I deem it prudent to deal with those allegations at the appropriate time and the proper forum. Submissions in relation to Section 60 sub 4 paragraph A to E. In terms of in accordance with Section 60 sub 4 paragraph A of the Criminal Procedure Act, I respectfully submit that I do not pose a threat to public safety or any particular person, as I am not a violent person to the general public, nor do I bear any resentment to any particular person. This is born out of the fact that I have no previous convictions or pending cases against me. I undertake to be present at every court appearance and follow every condition and instruction that the Honourable Court may impose, if any. I understand the charges against me and that a stern punishment may be imposed by the Honourable Court in the event that I am convicted. However, I respectfully submit that I remain presumed innocent, and I am confident that I will be found not guilty of these charges. In terms of and in accordance with Section 60 sub 4 paragraph B, I respectfully submit that there is no likelihood that I will attempt to evade my trial in the event that I am released on bail, as I have a fixed address which has been supplied to the state. In addition to this, I am self-employed with a business and have strong family and community ties to the Honourable Court's jurisdiction, and I am a stable member of the community. My entire family, specifically my wife and 3 minor children, reside in the Republic of South Africa, and I have no intention of leaving there. I submit that I do not pose a flight risk and will attend my court proceedings as directed, and I have expressed my willingness to attend my trial. Furthermore, I do possess a valid passport which will be gladly surrendered to the investigating officer should the Honourable Court deem it necessary. I have a valid legal defence to the allegations to submit that the presumption of innocence exists in our law. I have legal rights to freedom and liberty as enshrined in the Constitution. I am traceable and have offered my full cooperation to the SAPS since the time of my arrest. I do not want to live my life as a fugitive. In terms of and in accordance with Section 60 sub 4 paragraph C, I respectfully submit that I will not interfere with or intimidate the state witnesses. I undertake to have no contact whatsoever with the state witnesses and will submit myself to any bail conditions the court deems fit to impose in this regard. I do not have access to any of the evidence the state intends to utilize against me, therefore I respectfully submit that I cannot interfere with same. In terms of in accordance with Section 60 sub 4 paragraph D, I respectfully submit that I have not at any stage submitted false information to the police or the investigating officer. In terms of in accordance with Section 60 sub 4 paragraph E, I respectfully submit that my release will not result in public outcry, disturb the public order, or undermine the public peace or security. I will abide by the bail conditions that the Honourable Court deems fit to impose, and submit that I have an amount of 20,000 rand available in relation to the payment of bail. I respectfully submit that the interests of justice do not require my continued detention. I therefore respectfully request that the Honourable Court to release me on bail subject to any reasonable conditions that this Court may impose. I respectfully submit that by denying me my personal freedom, I will be severely prejudiced, as will the preparation of my defence. Your Worship, that affidavit is then signed by accused number 5 and duly commissioned. I request that it be marked as an exhibit, Your Worship. That would be the evidence in respect to the accused 5.
You may stand. Mr. Stradom, you confirm that the statement read out, it is yours, and this is evinced by the signature on the at the end of the statement. Very well. This is then accepted. It is marked as Exhibit J. Be seated. Yes, I have skipped I. I think that was canvassed previously. Good. I hear someone whispering about I. Is that all, Mr. Shaw?
Your Worship, that is the evidence for accused number 5.
Thank you. Mr. van Staden.
Morning, Your Worship.
Is it still morning?
It's still
It's all right. Proceed.
Your Worship, I did prepare an affidavit as my colleagues. I'm ready to read it out. I also gave a copy thereof for my learned colleagues at the FBH office. And I've got a copy for the state, for the magistrate as well.
Thank you. Proceed, sir.
Thank you, Your Worship.
Just before you do that, let us just confirm the accused you represent, Nicolas van Heerden. Very well, you may sit. Thank you, Mr. van Staden. Proceed.
I understand that police van Heerden declare under oath as follows. I am an adult female person and an accused in this case. The factors contained in this affidavit fall within my personal knowledge unless stated to the contrary and are true and correct. I am the applicant in this.
Sorry, just a minute. There seem to be some issues. Could you bring me up to speed, please?
Your Worship, I was just requested by my learning colleague just to bend the mic down to my colleague on this side.
Oh, there's one. Sorry, Your Worship, I didn't see that. I just requested him to bend it down, but I didn't see that he has a mic in front of him. I'm sorry about that.
It's all right. Thank you. Sorry for the interruption. Do proceed.
As the court pleases, Your Worship, the nature of the application is that the application for my release on bail pending the finalization of the above trial. The personal particulars, my identification number is 620911 0148 088. My date of birth is the 11th of September 1962. I'm a South African citizen. I have a passport which expired during the 18th of June 2024. See Annexure A. Your Worship, just on this point, we do have the original passport with us in court and it will be handed over to the investigating officer. I have travelled outside the borders of the Republic of South Africa to my son, Werner van Heerden, wedding in America. The only relatives that I have living outside the Republic of South Africa is my son Werner van Heerden, living in America for the past 10 years, and my other son Leon van Heerden, who works on a contract basis in the Netherlands. I have no assets outside the Republic of South Africa. Personal background, I was born in Bloemfontein in the Free State. I have a matric certificate. I have not undergone any tertiary training or education. Without my working career, I've always been working in the Republic of South Africa. The current status, I reside at 30 Thunderwood Crescent, Serengeti Golf and Wildlife Estate, Kempton Park. Alternative address is at 23 Magali Street, Koster, where I would be staying when released on bail. Mr. Schulenberg's contact number to confirm is 76-864-8449. This address has been confirmed by the investigating officer. See the affidavit of the investigating officer attached here too. I have resided at the same address for the period for 2 years. My previous residential addresses has always been in the Republic of South Africa, namely Bayswater 11, Alsale Street, Bloemfontein for 10 years. Erorand 10, Waterberg Street, Middelburg, Groenko 8A, Vos Street, Middelburg from 2006 till 2008 and 2008 till 2018. And Golfsig 4A, Mini Posma Street, Middelburg from 2018 to 2022. I'm currently single. I have no dependents. I am currently unemployed due to the fact that I resigned from Tarioco Pty Ltd or Forever Diamonds at Gold on the 1st of October 2024, see Annexure B. I do not own any fixed property. Should my bail application be granted, I will be able to afford the amount that is of 10,000 Rand towards bail. Should this honourable court set bail on a higher, then I will be able to raise it to 15,000. I submit that my son Wikus van Heeren and his wife are staying in South Africa and have grandchildren, and that I have 2 grandchildren. I have no previous convictions. That is the story of the antisocial behaviour, Your Worship. I have no previous convictions. I have no other pending criminal cases, outstanding warrants of arrest against me. I have been warned by my legal representative about the consequence of misleading the court about my previous and pending matters in terms of the provisions of Section 6011B of the Criminal Procedure Act as amended, which may result in my bail being revoked or being criminally prosecuted. Arrest and factual background here too. I was arrested on the 23rd of October 2024 after a warrant of arrest was applied for under Section 43 of Act 51 of 1977 as amended. I understand that I am charged with charges relating to racketeering, money laundering, theft, fraud offences in terms of the Banking Act. I am advised that the charges brought against me falls under the Schedule 5 of the Criminal Procedure Act. I intend to plead not guilty on the charges. Legal framework for the bail, Your Worship. I am advised that the relevant consideration that the court will have regard when exercising its discretion as to what the interests of justice should require. I set out in Section 64 of the CPA Act, and that I have to prove that there exist exceptional circumstances justifying the release on bail. I further submit that as provided for in Section 64A of the Act, I will not endanger the safety of the public, of any particular person, or commit any offence. I further submit that there is no evidence or any likelihood that I pose a danger to the public or individual safety. I further submit that as provided for in Section 64B of the Act, I will not attempt to evade any proceedings that may take place up to the conclusion of my trial. I intend to prove my innocence at the trial. I have no desire to forfeit everything I have worked for up till now and to become a fugitive of the criminal justice system. I further submit that as provided for in section 64C of the Act, I will not attempt to influence or intimidate any person or conceal or destroy any evidence. I am, to my knowledge, unaware of the identity of all the witnesses that may be called against me. Should I know the identity there of these witnesses, the court may impose any conditions that cause me to refrain from any contact with such a person, and I intend to abide by these conditions. I further submit that as provided in section 64D of the Act, I will not do anything that will determine or jeopardize the objective of the proper function of the criminal justice system, including the bail system. I further submit that as provided for in section 64E of the Act, I will not do anything that will in my way disturb the public order or in any way disturb the public order or undermine the public peace or security, not will my release on bail causes such effects. You wish that in further exceptional circumstances, the alleged crimes were committed according to the warrant of arrest during the period of 2019 to 2023 in the district of Bloemfontein. During November 2020, I started working for a company better known as Forever Diamonds and Gold, alternatively Tarioco Pty Ltd, owned by the accused, Mr. Liebenberg, until the 1st of October 2024 when I resigned. CNHB, I was appointed as the personal assistant, office manager of Mr. Liebenberg. Mr. Liebenberg made it intolerable to continue working at Tarioco Pty Ltd or Forever Diamonds and Gold. I knew about the facts that liquidators were appointed and were handling the liquidation inquest investigations on the company. I felt my duty to assist them and started to cooperate with them by meeting with them and handed over my laptop and cellular phone for the purpose of retrieving all the information thereof. I gave them my full cooperation even before and after my resignation. The Honourable Court may take into consideration exercising its discretion that the above are exceptional circumstances. During the above-mentioned period, I remained at the residence of my house and did not at any way attempt to change my residential address. I also gave my full cooperation to the police during my arrest and will continue giving my full cooperation in the event of any further investigations. I have at no stage intentionally or unlawfully committed any of the alleged crimes as stipulated on the arrest warrant. I am no longer a young woman and have no desire to end my days as a fugitive of law. Like most people, my age is 62 years. I suffer from ailments and illnesses usually associated with old age and will suffer greatly should I be detained in cells. I further undertake to adhere to any conditions that this Honourable Court may impose if this Honourable Court indeed exercise its discretion in my favour and order my release pending the finalisation of these proceedings. In the circumstances, I submit that my release is in the interest of justice and that I have proven the exceptional circumstances exist, justifying my release on bail. I therefore request the Honourable Court to order my release on bail pending the finalisation of the proceedings against me. This affidavit has been signed on the 21st of October here in Bloemfontein and commissioned accordingly.
You may stand, Ms. van Heerden. The statement that's just been read out, do you confirm that it is yours? See, that is this your signature as well?
I can't see it.
You can't see.
I've signed it.
You've signed what you can't see.
No, I signed it. Yes, that's my signature.
Thank you. You may see it.
Thank you.
The statement the statement is accepted as Exhibit K, Mr. Desiree.
As the court pleases, Your Worship, I don't know if the court would like to hear me on any further aspects like exceptional circumstances or...
That is an argument. I
That
see
is-
that you have attached
I did file heads of argument as well. Your
heads
Worship.
of argument. We will get to that at
Thank
the
you,
right
Worship.
time. Thank you. Is that evidence for
That's the evidence
accused?
for the application, Your Worship.
Thank you. Mr. Why do I always forget your name?
Conradi, Your Worship.
Mr. Conradi. Strange, my friend is Conradi and I forget. Thank you. Proceed, sir.
Thank you, Your Worship. I will then start with Johannes Petrus Badenhorst. That is then accused number 3. The certificate in terms of section 60, subsection 11, capital A, subsection A, read with schedule 5 of Act 51 of 1977. I, Marika Janse van Vuren, Deputy Director of Public Prosecutions, Gauteng, Pretoria, hereby authorize Advocate Conradi, the prosecutor in Court A, to proceed with an unopposed Schedule 5 bail application in the matter of Louis Liebenberg and 8 others in respect of accused 3, Johannes Petrus Badenhorst, court case number A 642/2024, Bronkhorstspruit Cas 339/10/2024, in respect of the following charges: contravening Section 2 of the Prevention of Organised Crime Act 121 of 1998, racketeering, contravention of Sections 4, 5, and 6 of the Prevention of Organised Crime Act 121 of 1998, money laundering, fraud and or theft, for the following reasons. He owes property and the address has been confirmed. He has no previous convictions. The investigating officer has no objection against the accused being released on bail. Your Worship, it's signed at Pretoria on the 30th of October 2024 by the learned advocate Janse van Vuren. If I may hand it up as an exhibit.
Please do. It's accepted, marked Exhibit L.
As it pleases the court.
Proceed.
Thank you, Worship. I'm then going to skip number 5 and move over to Christel Badenhorst. It's also a certificate in terms of Section 60, subsection 11, capital A, then small a, read with Schedule 5 of Act 51 of 1977. I'm Marika Janse van Vuren, Deputy Director of Public Prosecutions, Gauteng, Pretoria, hereby authorize Advocate Conradi, the prosecutor in Court A, to proceed with an unopposed Schedule 5 bail application in the matter of Louis Petrus Liebenberg and 8 others in respect of accused 6, Christel Badenhorst, court case number A 642/2024, Bronkhorstspruit Cas 339/10/2024, in respect of the following charges: contravening Section 2 of the Prevention of Organised Crime Act 121 of 1998, racketeering, contravening Sections 4, 5, and 6 of the Prevention of Organised Crime Act 121 of 1998, money laundering, fraud and or theft, for the following reasons. She owns fixed property and the address has been confirmed. She has no previous convictions. The investigating officer has no objection against the accused being released on bail. Your Worship, this certificate is also signed at Pretoria on the 30th day of October 2024 by the learned advocate Janse van Vieren.
Thank you. It's accepted, marked Exhibit M.
M. As it pleases the court, Your Worship. I will then continue with number 5, Your Worship.
Proceed.
It's also a certificate in terms of section 60, subsection 11, capital A, then small a, read with Schedule 5 of Act 51 of 1977. I, Marika Janse van Vieren, Deputy Director of Public Prosecutions, Gauteng, Pretoria, hereby authorize Advocate Conradi, the prosecutor in Court A, to proceed with an unopposed Schedule 5 bail application in the matter of Louis Liebenberg and 8 others in respect of accused 5, Adrian Dewald Strydom. Court case number A642/2024, Bronkhorstspruit case 339/10/2024 in respect of the following charges. Contravening Section 2 of the Prevention of Organised Crime Act 121 of 1998, racketeering. Contravening Sections 4, 5 and 6 of the Prevention of Organised Crime Act 121 of 1998, money laundering, fraud and or theft, for the following reasons. He has no previous convictions. The investigating officer has no objection against the accused being released on bail. He is married and has 2 minor children. He is not considered to be a flight risk. Your Worship, this certificate is also signed at Pretoria on the 31st of October 2024 by the learned advocate Janse van Vieren.
Thank you. The document is accepted, is marked as Exhibit N.
As it pleases the court, Your Worship. Then lastly, for Nicolis van Heerden, accused number 7. It's also a certificate in terms of section 60, subsection 11, capital A, and small a, read with Schedule 5 of Act 51 of 1977. I, Marika Janse van Vieren, Deputy Director of Public Prosecutions, Gauteng, Pretoria, hereby authorize Advocate Conradi, the prosecutor in Court A, to proceed with an unopposed Schedule 5 bail application in the matter of Louis Liebenberg and 8 others in respect of accused number 7, Nicolis van Heerden, court case number A642/2024, Bronkhorstspruit case 339/10/24 in respect of the following charges. Contravening Section 2 of the Prevention of Organised Crime Act 121 of 1998, racketeering. Contravening Sections 4, 5 and 6 of the Prevention of Organised Crime Act 121 of 1998, money laundering, fraud and or theft, for the following reasons. She has no previous convictions. The investigating officer has no objection against the accused being released on bail. She is not a flight risk. Your Worship, this certificate is also signed at Pretoria on the 31st of October 2024 by the learned advocate Janse van Vieren. As it pleases the court.
Thank you. The document is accepted, marked as Exhibit P.
As it pleases the court, Your Worship.
Thank you, Mr.
Thank you, Your Worship.
Conradi.
The state is not going to provide further evidence against those 4 accused persons. However, I will address the court after my colleagues has had the opportunity.
Thank you.
As it pleases the court.
Mr. Jordan.
Please support your motion. Your Worship, my closing address will be in respect of both the accused 3 and 6, as they share the same details and the same facts. Your Worship, it has been placed before this court by the state in the matter that the addresses has been confirmed, that there's no previous or prior charges brought against them, nor any convictions, and that there's no objection in respect of bail being granted. Your Worship, that means that the onus lies squarely on the accused persons to show that it's in the best interest of justice that they be so released on bail. Your Worship, I would submit that the accused has placed before this court that both of them are parents to minor children. They are married to one another. Both of them are currently...
The age has not been indicated, neither have their birth certificates.
Your Worship, in both portions, in section 3.1,
Just a minute.
under personal circumstances, is stated...
I'm looking at Exhibit G.
Your Worship, G, yes.
Yes.
Yes. G and H for that matter.
Yes.
States that I have 3 minor children.
Yes, but
Your Worship,
how minor are they?
Your Worship, I do have instructions to that effect. I can confirm the ages.
Yes, because I noted this. It is quite imperative that the court knows.
Certainly, Your
A
Worship.
minor of 17 years will be treated differently from a minor of 2 years.
Certainly, Your Worship. Your Worship, there are 3 sons, aged 5, 13, and 14 respectively.
5,
13,
13.
and 14.
Why was it not indicated?
Your Worship, as...
It's all right, it's a slip of a mind.
Certainly, Your Worship. Your Worship, I've also been advised that the 13 and the 14-year-olds are in the process of writing exams at the moment. I do understand that that's not canvassed in the statement. I received that this morning. Your Worship, be that as it may, I would submit that it is in the best interest of any minor child to have their parent in their lives and not unnecessarily removed. At this stage, there is case law before this court today, and the case law is evident that parties should not be deemed and sentenced provisionally, and that bail should not deem as such. Your Worship, I would submit that a proper case has been made out that the parties have placed circumstances before this court that it would be just and equitable to be released on bail. They are not parties whom can influence the matter going forward. They have given and are giving their full cooperation to both the state and the liquidators in the matter as set out in the papers. Your Worship, they own fixed property. They have lived there for a significant amount of time. Well, 2.5 years, Your Worship.
That's not significant.
Your Worship, they have lived there, and despite the matter being in the media and coming to their attention, they've made no attempt to flee. They've been outright to the state, Your Worship, and therefore I would submit that a proper case has been made out. In respect of amount, Your Worship.
Before we get to the amount, because the amount would not, it's not so much of an issue to me, but
Certainly, Your
it
Worship.
is their circumstance that is an issue to me, and I want us to talk more about that.
Your Worship.
I would have expected a little more from you, okay, you were not here previously.
Thank you, Your
I
Worship.
forgive you for that.
Your Worship, in respect of what can I address
please,
the court?
Please hear me out. You see, at their age, 41 and 42 years of age, boom, Artepius Sport, that's where they live. They have, like the biblical Melchizedek, they have no past except from 2022. And that is worrisome to me, because I have to determine their stability. And stability of 2 years is not stability at all. Do you get my concerns?
Your Worship, I do understand.
So with that understanding, please address me.
Your Worship, I do have instructions to that effect.
Please do.
Your Worship, in respect of both parties, they worked abroad prior to COVID. I believe it was 2017 through to 2018 or 2019, at which stage they came back to South Africa. They sought employment on this side, and that they then obtained employment with Your Worship, I think with Forever Diamonds at that stage, which was early in 2020. I do not have the party's address for that period of time. Could I confirm same, Your Worship?
It's going to be what? It's not. It's going to be an ipsy-dixy. but
Yes.
let us leave it there.
Your Worship,
Yes, the other thing that is of worry to me,
yes,
both of them are unemployed.
that's
currently.
correct, Your Worship.
And when I look at the deeds, the document attached, the value of the property, how are they servicing such unless it is fully paid, how are they servicing the bond, the mortgage? That is of worry to me, because if it is not sufficiently addressed, I may be dealing with people who are going to be evicted in any time soon by the bank, and the property be
Your Worship,
repossessed.
Yes.
So I am interested in that.
in that respect, can I refer you to page 1 of the database property of
Yes.
Your Worship, under endorsements, bond number, Your Worship would note that both bonds there registered are of previous owners, both to R0. So, Your Worship, I would submit in terms of the deeds records that is not a risk, and that there is no bond outstanding, Your Worship.
All right.
I take that from the information as received from the deeds office.
Well, the deeds office will not. They are indebted to. If they are still indebted, they'll be indebted to the bank. The deeds office will not indicate whether they are indebted, because they.
Your Worship, a bond is registered against the property, and such bond is recorded as an endorsement
Yeah.
on the property record at the deeds office. So that would indeed reflect on the deeds office records as a caveat to any interested party in that property.
Who supports them? How do they make ends meet?
Your Worship, at this stage, I don't have that information. Can I obtain information for a second from my client, Your Worship?
You may.
Thank you, Your Worship. Your Worship, in respect of the employment, that I would just like to add on the on the sixth accused. She's a qualified school teacher, and she's got a history of teaching in South Africa to somewhat 18 years as a school teacher, first in the primary school and then in the high school. In respect of the party's financial position, the third accused has been employed with Forever Diamonds until somewhat 2 or 3 months back. Following that, they started selling their movable assets here and there to generate money to pay for their overheads and their living expenses. And then, of course, in the meantime, also seeking employment. As the third accused has set out, he's already started going for interviews again. So they've been making ends meet by selling off assets where needed, Your Worship. There's no creditors knocking on the door in respect of the property. So the address is fixed with no chance of moving, Your Worship. And I also confirm that there's no bond outstanding on the property, Your Worship. So no monthly installments other than the normal expenses.
Municipal levies, rates, taxes?
Yes, the normal expenses, no bond.
No, I'm talking about that. How do they cover that?
That's what the third has stated, that you worked until about 3 months back when you still had an income, and then thereafter they've been selling movables, which included quad motorbikes and so on to cover the expenses, Your Worship.
Now, that being the case, how would this amount proposed as bail Where would it come from?
Your Worship, the bail would be posted by the sixth accused mother. They sold a motor vehicle to generate cash flow.
How much was, what motor vehicle was it, which year, and how much was it sold for?
Your Worship, the legal representative for the mother was here earlier on. I don't see her at the moment, Your Worship,
Yeah.
but I don't have that information. I was
Get
just.
it, please.
Thank you, Your Worship. Your Worship, may I approach the mother? Thank
Yes.
you.
Whilst he's busy with that, it is 5 minutes before 1. Would you be amenable for us to proceed, continue, or should we break?
Your Worship, my suggestion would have been, as soon as we finalize these 4 bail applications, to ask for a short comfort break.
So we proceed until we get finished with the 4.
That will be my suggestion, Your Worship, and then we can, when we convene again, we can start with number 9.
Anyone with a different view? We're just talking about whether we should take a break for the lunch or we should continue until the 4 applications are dealt with.
I'm in the court's hands, Your Worship. I've got no specific preference either way.
Thank you, Mr. Anyone with a different view?
If I may ask, my client asked me that if he could just quickly stand and stretch his
He
legs.
may stand, he's free to do that.
As court pleases.
Yes.
Thank you, Your Worship.
I take it that everyone is amenable to us continuing. Mr. Odali, are you okay? I have to respect your labor rights. We can continue. Okay. The gentleman, Mr. Can we continue? Do you want your lunch? I respect your lunch.
No, I do understand. That's the contract is
We can continue.
And after
I don't want that some things outside that it denies us lunch.
No,
No.
I don't.
Thank you. Thank you. Proceed, Mr.
Thank you, Worship. Your Worship, I have in front of me a purchase agreement from We Buy Cars in respect of the motor vehicle that I referred to, which was sold, Your Worship. This has also, I believe, been submitted to the Hawks for their perusal and confirmation. However, Your Worship, it deals with a 2023 Toyota Corolla Cross, which was sold to the net value of somewhat 325,000 Rand, Your Worship. That amount, of course, going to the mother of accused number 3 and the in-law mother of 3 and mother of 6. She will be paying the bail and also in the interim using that to cover living expenses and so forth, Your Worship. Of course, also legal fees. So that is where the money has been generated from and where the money would be coming from in respect of bail monies.
All right. Anything else?
Your Worship, other than submitting that a proper case has been made out, nothing further from our side.
Thank you. Mr. Conradi, on accused number 3 and 6.
Thank you, Your Worship. Your Worship, there's a few comments. As mentioned, the state is not opposing to bail, but I noticed that my colleague in both of their statements refers in paragraph 8 to exceptional circumstances, Your Worship, and I'd just like to bring it under the court's attention that it's a Schedule 5 offence, so it's in the interest of justice.
It's all right. I've noted that, but they always do that, and we overlook that.
No problem, Your Worship. I just wanted to bring that under the court's attention regarding 3 and 6. As mentioned then, Your Worship, the state does not oppose bail.
And the amount because the state is not opposing bail, I have not been asking a lot, as you can see, on relation to whether they qualify for bail, but it is on the question of the quantum.
That is correct, Your Worship. With all respect, on the previous occasion, I listened to the court's judgment regarding the quantum, where the court indicated specifically that the court takes into consideration the different circumstances of each and every person. It therefore differs from person A to person Z, of course. And Your Worship, taking into consideration as well that the number 2 and 4, if I remember, 2 and 4 was released on 20,000 rand. The state will not oppose if the court make a ruling in the same amount, more or less, of 20,000, taking into consideration their respective personal circumstances.
Thank you, Mr. Conradi.
As it pleases the court.
The accused number 5, Mr. Shaw.
Thank you, Your Worship. Your Worship, very similar to what my learned friend has just said, for the sake of brevity, I'll keep it short. Your Worship, I would also submit respectfully that a proper case has been made out for the release of accused 5 on bail, and that it would be in the interest of justice not to detain him any further. Your Worship, this is also specifically in light of no opposition for the factors laid out by my learned friend for the state. Your Worship, my client, accused number 5, has a fixed address. He's not considered a flight risk, and has three minor children. Your Worship, I know in the certificate that was reference was made to 2 minor children. He actually has 3 minor children.
Yes, their ages, Mr. Shaw.
Your Worship, it is contained in the affidavit. It's a boy aged 5, a minor daughter aged 2, and his eldest from a previous relationship is 13.
So,
Your Worship, that can be found.
Just a minute. Yes.
Your Worship, that can be found at paragraph 18 of his affidavit. It's a minor boy, aged 5, a minor girl, aged 2, and his eldest is 13 from a previous relationship.
Yes.
Your Worship, I would have no further submissions unless there's anything in particular that the Honourable Court would like me to address.
This proposed 20,000 rand for bail, where would it come from?
Your Worship, those funds have been raised, one in part from his wife, who's employed, and her salary, and secondly with funds that have been raised by his mother and father, who reside on the same property.
Are they working? Are
Your
they
Worship,
employed? What is their status, employment-wise?
I would need to take an instruction in respect of the parents, Your Worship.
Go ahead.
May I do so?
Yes. Mr. Jordan, correct me if I'm mistaken. The person you consulted with right at the last row of the courtroom, is that not accused number What is that? Not one of the accused.
Your Worship, she is one of the accused. She is out on bail.
Yes, accused number 2.
I don't have her number. Accused number 4.
Number 4.
From my learning colleague, Your Worship. Yes.
Yes.
That's correct. Thank you, Your Worship.
Just to make sure my observations were
Yes,
not misplaced.
That is correct. As I said, she is the mother of the accused number 6.
Thank you, Your Worship. I'm indebted. Your Worship, the funds, as I said, come from the accused wife, her salary, a portion of her salary. Then the accused mother-in-law is employed as a guest house manager,
Yes.
and his mother, accused mother, is employed as a school secretary to the school principal. So from those 3 people, the accused wife, his mother and mother-in-law, and their salaries, they've been able to put aside collectively the funds available for bail. The accused father is elderly, he's 82 and unemployed, Your Worship.
Is he here?
He's not here.
All right.
As a court pleases, Your Worship.
Thank you. Yes, sir.
Thank you, Your Worship. Comment regarding accused number 5. I wish to add that the state is not in possession of the passport of accused number 5 at this stage. It has not been handed over to the investigating officer, and I did confirm that whilst this court was in session. State would request the passport to be handed over to the investigating officer. Regarding the quantum, Your Worship, it's the same argument that the state already led, and then, as mentioned, the state is not opposed to bail for accused number 5 in this matter. As it pleases.
Thank you. Mr. Van Staden.
The court pleases, Your Worship. Worship, I think it's common cause that it is a Schedule 5 offence, and the onus of proof lies on the applicant. So what I'm going to do, for argument's sake, is that I'm going to address the court in respect of exceptional circumstances and in the interest of justice, Your Worship.
Perhaps the interest of justice will be more suitable.
Thank you, Your Worship. Then, once the court established that exceptional circumstances is indeed established, then section 65 to 66 or 69 must come into operation, and then you must wait 64 A to 9 or B to with 65 and to 9, and then all the factors contained in 65 to 69 must be tested to 64. And then, if the court may find that there is existence of the exceptional circumstances, then it will be in the interest of justice for the applicant to be released on bail. I think that hopefully clarifies my point of view.
Thank you, Mr. Van Staden. Proceed.
I'll leave it then in the rest of the answer for the court.
Would you care to address the court on the quantum, Mr. Van Staden?
As the court pleases, Your Worship, in the affidavit it says, or it is only a submission of 10,000 or 15,000 rand. I hear that my learned colleague said all the other were released on a 20,000 rand. The reason why we're saying this is that by the applicant's children raised 10,000 rand in cash with me that can be paid today. If that is, the court would grant bail on a higher amount, then that will be accommodated and up till 15,000 rand.
Yeah. This morning I listened to the news update and they informed me that the rand-dollar exchange is quite profitable.
I'm not plea bargaining here, Your Worship. All I'm asking is just for
I'm asking
use your discretion.
Yeah, indeed I would, but the discretion must be, there must be rationale for the discretion to be exercised. Now, I'm raising this because two of the sons, the one is at the US and the other one is in the Netherlands. Now, rand, dollar, they use a euro that side, which is even more
Your Worship,
and
then-
appetizing.
As a court pleaser, Your Worship, then I'm not bargaining here. What I'm trying to say
The point is, Mr. Van Staden, I beg your pardon, I mean not to be rude to you. The point is, in the event, as it is argued, that it is the sons who would, or the children, who will be raising the funds for her bail, which is not a misplaced suggestion, but when those that are benefactors to the accused provide something, they must provide something that will be encouraging them to police her to come back so they don't lose their investment. That is, now if you are in the US or you are in the Netherlands, 15,000 rands compared to the euro, compared to the dollar, it can go away.
You wish may we argue.
Please do.
I'm so sorry, I haven't got the knowledge to argue with the judge, magistrate, but what I will suggest is, if all the other people are getting 20,000 rand bail, then...
Only two
been,
got 20,000.
Yes, only two, but I see where the state is going to, Your Worship.
And they proposed 50,000 and it
But
went
now
to
it's 20 and the other one was 100,000.
Yes, so you can say, I don't want to be predictable.
Exactly.
You can ask your colleague next door.
So what I'm trying to say, Your Worship, if the court may, in exercising its discretion, that it's 20,000 and it will be paid, it can be paid. And the surety that I have for that is that then the exceptional circumstances are always there more, because then she will not flee. She will stand the trial. Otherwise, if she do not appear in court, it will be forfeited to the state.
Sometimes let me epitomize this in simple terms. If I were to be on the wrong side of the law and I'm given 10 years imprisonment or 15,000 rand, fine. I will choose to forfeit the 15,000 rand than to forfeit 10 years imprisonment. Do you see the logic?
I do, Your Worship, but that's
I hope I will never be in that situation, and I do my best not to be.
yes, Your Worship, but then on the other hand, you do have the discretion in seeing that this is a 62-year-old age woman. She's single. She's going to stay at the alternative address, which has been confirmed by the investigating officer.
Why is she moving from here to there?
Because you will see in the statement from the police officer, which is in court, it says that the rental agreement is ending the end of this month, as today.
Yes.
And then we asked the state if we can proceed on that, and then they recommend, before we bring this application today, rather get an alternative address that they can be confirmed. And that is the same address where accused number 4 is staying. That's what's That's correct. And yeah.
No, is she not moving to Koster?
Yes, 23.
I think Koster is somewhere in the northwest.
That's correct, Your Worship, but it was confirmed by the...
No, I'm not disputing the confirmation. My point is, why does she okay, there's an explanation now why she's moving from Kempton Park to Coster.
Correct.
But the point is, Coster takes quite some time, some money for her to come back from each time the matter has to be serviced in court, and she is unemployed, and therefore the probability of defaulting.
I may answer the court on that.
Please
point.
do.
Your Worship, as the court already know, the accused number 4, who is in court, who's already on bail, they are going to start with I don't know exactly what type of business it will be, but they're going to start together and do it. So accused number 4 must be in court as well, so they will travel together. So that will sort that, if that is a means of coming to make sure that she do come to court.
All right. Thank you, Mr. Van Staden.
Thank you, Your Worship.
Mr. Conradi, Mr. Fenker. Your client requested to remain in attendance when the applications for bail for accused 3, 5, 6, and 7 are held. There are documents that have been submitted here, especially for accused number I will favor you with that. Yes, accused number 7. There is a document that is quite important, which I think, in the interest of justice, must be brought to your attention as well as to the attention of accused number, your client, Mr. Liebenberg. It's written in Afrikaans. I've indicated I have no problem with it. I have read the document. Perhaps for record purposes, I would ask you, Mr. Van Staden, to read it, Annexure B, so that he takes cognizance of.
You have an extra copy, Your Worship.
All right. Please just read it so that accused number, Mr. Liebenberg, he takes cognizance of that. And
Is that the part of the laptop and the cell phone?
Annexure B, the
Oh, yes,
document
the
written in
resolution.
Afrikaans.
The
Yeah.
resolution. Your Worship, I will give a copy to my learned colleague, and then we can discuss it with the accused, number 1. Or do you need me to read it out now?
Look, this is an open court, and it is quite important that it be known. So perhaps we should read it out, please.
Thank you, Your Worship. It's written in Afrikaans, but it's dated the 3rd of October 2024. Louis en Desiree, ek wil graag vanaand weer eens die volgende met betrekking tot die besigheid en kantoor onder julle aandag bring. Die situasie met die besigheid en hofsaake is baie onseker en voel vir ons asof dit nie vorder nie. Wanneer daar aksies deur likwidateurs is daar nooit regshulp vir ons nie. En is ons op ons eie aangewese. Dit beïnvloed ook ons persoonlike bates en lewensomstandighede. As gevolg van bogenoemde en die feit dat die salarisse so ongereeld is die situasie in die kantoor onder ons personeel ook baie onseker en moeilik. Die personeel het die geld vir brandstof, kos, skoolgeld ensovoorts. Van ons personeel is al uit hul huise gesit oor wanbetaling. Die mediese fonds het ons mediese fonds gekanselleer as gevolg van wanbetaling. Die personeel kan ook nie beplan nie, omdat daar nie kommunikasie is met betrekking tot die betaling nie, soos Sonet se boodskap lees. Die vennote raak meer en meer onseker en omgekrap omdat daar pakkies en onttrekkings nie uitbetaal nie en plaas verder druk op die personeel. In die lig van bogenoemde omstandighede voel ek dat dit die beste sal wees vir my gesondheid en persoonlike omstandighede om met onmiddellike effek te bedank, aangesien omstandighede dit onmoontlik maak om my werk na die beste van my vermoë te doen. Hierdie is vir my 'n moeilike en hartseer besluit, maar onder omstandighede die beste. Dankie is 'n klein woord, maar ek sal julle altyd dankbaar wees vir die goeie tye, alles wat julle vir ons gedoen het. Ek besef die omstandighede glad nie normaal is nie en alles verander ten spyte van ons loyaliteit en positiwiteit. Ek sal alle dokumente, navrae en uitgawes op datum kry en afgee by die kantoor. En wens julle voorspoed toe. En dit is deur die Nikki van Heerden. Dit is haar that's her alias at work, so that is the accused number 7's signature on this document.
Thank you. You took.
Thank you very much, Bishop. I appreciate it. I take cognizance of the letter, and I'll also get a copy from another friend to discuss it.
Thank you. Anyone who wishes to address the court further? Is that?
Your Worship, there's just one aspect that I would like to bring under the court's attention. When my colleague read the statement of accused number 7 into the record, I would like to refer to paragraph 5.1. He read a cell phone number, And the typed version says the last 4 digits 8559, but my colleague said 8449. I just want to establish which one is the correct one. Is the number 8559 or 8449?
Worship, I will just get to that.
It's paragraph 5.1.
Thank you. I will repeat 076 864 8559.
Your Worship, I do have that, and I thank the court, Your Worship. And then lastly, I would like to add that the state has not, or the investigating officer has not received the passport of accused number 7 as well. We would request that it be handed over to the investigating officer. Taking the quantum into consideration, Your Worship, I already addressed the court on the stance of the state, and then once again, the state does not oppose bail as mentioned, as it pleases the court, Your Worship.
Please do.
As the court pleases with, I will add it over.
As it pleases the court.
Your Worship, just in respect, my learned friend mentioned also for accused number 5, I am in possession of the passport. As well.
Okay.
We have no objections.
It is quite unconventional, but it's all right.
Your Worship, I'm just making a suggestion. I don't know if the court wants to give judgment now, or can we maybe adjourn for a comfort break and then come back and the court gives us a judgment, or?
I am ready with that, as you know, I work overdrive my mind. But
Okay.
if you want a break, I will take a break.
I had some people ask me to request for a break.
I will not be long. When I come back, I just want us to flow again.
As it pleases the court, can we quickly take a break then, please? Or is the court not going to be long? I don't know.
No, I'm not going to
Okay,
be long.
it's
I'm
fine.
not
Your
going
Worship.
to be long.
As it pleases the court.
Thank you. The court, I have listened to all the evidence and I have thoroughly applied my mind. I'm not going to make any reference in the judgment to determine the release or otherwise of the accused. I'm not going to make any specific reference to case law. The principles are well known to all of us. It will not be. It will not interest anyone to come to make reference to cases. I'm aware of State versus Atchison Namibian decision. I'm aware of State versus C. I'm aware of State versus Bronco. It went right up to the SCA by Justice Kachalia. He's retired now. I'm aware of all of those. So it's not really going to be. I'm aware of judgments by Justice Krichler, my hero. Constitutional court judgments, State versus Lamini, State versus Chavalala, Skitekat, you name them. So it's not going to be it's not really going to be of any, if at all, it's going to be only of academic importance, one to shine, and I'm not here to shine, I'm here to administer justice. I have taken the consideration of all 4 accused, number 2, number 5, number 6, and number 7 in their applications. If I were to really be critical or critique their applications, you will not be in a favorable position. But bail is not it's not an academic exercise like at university. The interest of justice, fortunate for you, is the test that the court has to apply. It is not exceptional circumstances that the court has to apply. That being the case, I will start, for example, with accused number 7. I'm doing that deliberately because her circumstances are much, much easier to adjudicate. Although she is a person that has, in the event that she were to choose to elope or to abscond to the Netherlands, to the United States, she would be comfortable that side because there are children both in those 2 countries. However, the court must then also take into account that the probability and the feasibility of she being extradited back to South Africa, it's much easier when one takes into account the extradition treaty existing between South Africa and the Netherlands, extradition treaty existing between South Africa and the United States of America. So it is not something that's going to be, it will take an effort, but it will not be an insurmountable mountain to climb. So at the advanced age that she is, it is inconceivable that she would also choose to elope, particularly taking into account the non-opposition of bail in her circumstance, and also the fact that she has no particular sizable property that can be realized for her to make it out of the country easily. For that reason, the court has decided that bail will be set for accused number 7. You may stand, Mrs. Van Heerden. Bail, you have made a case, not a good case, I must say, but a case nevertheless to be released on bail on a balance of probabilities that the court has decided that bail would be set for you. The amount will be 5,000 rand. There would not be any particular conditions attached to that release on bail. The amount is the belief and the reasoning of the court that it is fair enough to encourage you to stand your trial, and particularly looking and considering the contents of the affidavit that has been submitted to be released on bail. Do you understand? Oh, very well. You may be seated. Accused number 6, you may stand. Equally so, the court has, there are circumstances that are quite worrisome in relation to your application, as I have engaged your lawyer when him and I were interacting on this application. The question of the fact that you are not I still have doubts, but I will give you the benefit of the doubt about the property, because owning a property of 2.2 million goes with certain obligations. Now, when those obligations are not met, the municipal obligations, the children you have, your own life as well, and if I still have my views about what your lawyer have said about the question of the mortgage, whether it is the property is still mortgaged or not, but that is not a point that I will canvass for now. Fact of the matter is that in the event that you decided to elope, there is something to lose, and with that there would also be a comfort to release you on bail. And the fact that there are children involved, and it is a factor, very important factor to be taken into account, because the court must, in terms of the Children's Act, also take the interest of the children. We do not even know, and it was not canvassed, what has happened from the date of your arrest to this point, where the children are they at a place of safety, are they in foster care, are they let alone, are they with grandparents? We do not know, because the grandparent was equally with you here until the bail was granted. But be that as it may, the court will take that factor as well into account, maybe for the sake of the children as well. That bail will be set at an amount of 5,000 rand for yourself as well. You may be seated. You understand that before you... Very well. And then in relation to accused number 3 and accused number 3, no, you sit. Your circumstance, what has been said in relation to accused number 5, number 6, your wife, it's more or less the same mutatis mutandis, except that you were here previously. I'm not a person who can be fooled easily. I don't say I cannot be fooled, but I'm not a person who can be fooled easily. You say the business that you operate is not making any real profit. It is it has just been established. Now, yes? Oh, sorry, I'm mixing. You are not employed, I beg your pardon. I will come to that. But in the same vein, there is the fact that you are living at a property that is 2.2 M and you are not working. You apply for bail, you have attended an interview, but you are not in any way, let me consult my notes, in any way gainfully employed. But if one were to go by the argument that your lawyer has presented, then nothing impedes you, even your wife, to take a loan against that property. Nothing. It can, in fact, if one were to go according to the argument that your lawyer has advanced in relation to that property, the court should be looking at a much, much higher amount, because if the property is 2.2 million, the bank will be, and it is settled, the bank will be more than willing to give you an advance of 4.4 million. So there's really nothing that can impede or that can cause the court to be criticized if the court were to look at an amount that is settling among the stars. But bail is not punishment. Bail is not sentence. Bail is an encouragement for the person to attend court and stand his trial until a verdict is pronounced, as I have said it previously in the judgment relating to accused number 2 and number 4. So with that in mind, the court's of the view that an amount of 15,000 rand will be suitable in the circumstances. You understand? You stand? You understand? Very well, you may sit. Accused number 5, you may stand. You have 13 employees, but you're not making any profit. Nothing. Let me read this to everyone. Section 50, subsection 6D of the Criminal Procedure Act provides that if the court is not satisfied that enough evidence has been presented to the court can postpone the matter for that evidence to be presented. Section 60, subsection 3 repeats the same, and I will read it. Perhaps let me just go to 50. I'm not reading this to scare you. I just want to understand that the court has got tremendous powers. I can even ask you to submit your returns that you submit to SARS as a professional taxpayer, for me to thoroughly look at them and see whether this indigence that you present to the court is real or otherwise. The court before which a person is brought in terms of this subsection, that is 50 sub 6D, may postpone any bail proceedings or bail application to any date for a period not exceeding 7 days. We have passed that on the terms which the court may deem fit. If the court is of the opinion that it has no sufficient information or evidence at its disposal to reach a decision on the bail application. Nothing impedes me looking at this to say, bring your SARS returns, bring your bank statements, let me look at them independently and satisfy myself that the company is indeed not making any profit. I cannot imagine that a company with 13 employees would be in that position. Otherwise, the employees would have been laid off. But that is the one factor that the court has to take into account. I must also consider the exhibits, the non-opposition of bail that the state has also indicated. Justice Skrifler, my hero, says it will be a travesty to keep a person in custody who the interest of justice dictates that he be released on bail, or a person who's got a cast iron defense. Now, there has not been any defense mentioned in this regard, neither has there been any evidence presented by the state to indicate to the court how strong their evidence is vis-a-vis the defense that the defense has got. And our law, a very beautiful law, although they criticize it, says that where there is doubt, it must benefit the accused person. It is only for that particular principle that the court will be leaning towards granting you bail in this application. Just remember that. That being the case, therefore, the court has decided that bail in the amount of 20,000 rand is set for you. Upon payment, you will be released on the condition that you are again at this court and you remain in attendance until the matter is dealt with. Do you understand? Mr. Conradi, I think your request for the court to adjourn is more suitable now.
Thank you, Bush. Adjournment. Can the court give us an indication when we will resume? Are we taking a lunch break, Your Worship?
I'm not a person in favor of lunch, but I respect the people who want their lunch breaks.
It's 22:02 at this moment, Your Worship. I don't know what time.
Can we make it 20 at 2 o'clock? Or do people want more time?
Can we give it a motion boldly some half an hour, 10 past 2 perhaps?
10 past 2.
As it pleases the court, Your Worship.
Excuse me, Your Worship. If we pay the bail now, are we excused for the rest of? Because otherwise we have to sit here then, pay the bail, my time can be released, and the other accused cases already been postponed to the 4th of February.
Accused number, stand, Mr. Stand. Upon payment of bail at the amount that have been set, and the passports have already been submitted to the state, You will be released on the condition that 25, I beg your pardon, 4 February 2025, you appear again at this court 8:30 in the morning, and you remain in attendance until the matter is dealt with. Do you understand? 4 February 2025, diarize it. Mr. Van Staden, does it provide for your comfort?
Thank you, Worship. May I be excused?
Mr. Conradi, are you happy with that?
Thank you, Worship.
Your Worship, I think I speak on behalf of my colleagues, and that concludes our roles. May we then also be excused?
No? Court adjourns.
Thank you.
Thank you, Your Worship. Thank you, Worship. If I may recall, case number A642, State versus Louis Liebenberg, as well as Desiree Liebenberg, accused number 1 and 9, Your Worship. Thank you, Worship. Firstly, I received a request from Warrant Officer Mashlangu, who is the court orderly in charge of all the court orderlies and the prisoners, etc., informing me that usually they depart around 2:15 to take the accused persons or persons in custody back to Jose Mampuru. We are also sitting with accused number 9, and she is held at Ridgeville prison. So there's a request from the court orderly that we postpone or remand actually this matter, Your Worship, so that they can depart and take them back to the respective prisons.
Thank you. Over and above that, which will be ventilated, Mr. Fenter,
Yes, Your Worship.
earlier, Mr. Conradi as well, the state made an application to have the matter postponed to 25 November,
That's correct.
which you objected to, and your objection was upheld, proposing that the matter be dealt with on the 8th of November.
That's correct.
Appreciate that I'm a visiting magistrate here. When I didn't have the benefit of the diary at the time. During the adjournment, I have been favored with the diary, and I am informed that this court that we are currently using is on Fridays, which will be the 8th of November, is used by the regional court, and the other court is fully congested for that date. That being the case, in the absence of another space, we would not be able to proceed with this matter on those premises. I would therefore propose and suggest that we look at another date other than the 8th of November. A date later or a date earlier, but a date that will allow us to do the business without any.
As court pleases, Your Worship, we would also obviously still want the soonest available dates, but I can suggest, according to our council's availability as well, if the court would just bear with me for a second, is 11, 12, or 13th of November.
Who can I send? Mr. Udari? May I ask you a favor, please? The 13th seemed to be okay, but just confirm with the...
Your Worship,
Yes?
I'm sorry to interrupt. There's no prosecutor available on the 13th to come and assist with this matter.
All right. No. What? Sorry.
That entire week, Your Worship.
For the entire week?
Yes.
Yes.
I am open on the 18th as well as the 19th, Your Worship.
Thank you, Mr. Sorry for that, Mr. Conradi. I almost forgot to consult.
No problem, Your Worship. Thank you.
Mr. Venter, the
If I may
18th.
just-
Yes,
If I may just quickly take instructions.
please do.
Worship, I trust this is also going to have an impact on my application.
I beg yours.
I trust that this is also going to have an impact on my application because, as what Mr. Kundari told the court, that we need to the prisoners need to be taken back to the various prisons. We will not be able to proceed with the application this afternoon.
That is one of the things. I thought this was going to be much easier to get a date of postponement than to deal with the substantive application. That's why I did not.
Because it's got serious implications as far as accused number 9 is concerned.
I will hear you, Mr. Van Heerden. I will hear you thoroughly.
Thank
I
you,
will
Mr.
hear you thoroughly.
Your Worship, I have taken instructions from my client, and unfortunately my client is saying that he has a constitutional right to have this bail heard as early as possible. The state is the one that's bringing him here before court, and now they want to push it as far as possible because they're not available for a certain week. I mean, there's a whole prosecuting team. I mean, there can be somebody else available to come and do this bail if they need to. I mean, the prosecutor that was initially doing the bail, when she wasn't available anymore, there was somebody else that could fill in for that as well. At this stage, my instruction is that my client wants to proceed as early as possible with this bail application. He's got the 7 days period that he's looking at, and that is where I can't agree to a later date at this stage. I'm instructed.
Thank you, sir. That 7 days is quite misplaced. The 7 days it presupposes the initial stage of upon his first appearance, but thereafter it is not cast in stone that it will always be 7 days. I am fully aware and I am fully mindful that bail in its essence is an agent application. It must not be dragged out unreasonably just as a form of punishment to prolong incarceration. But at the same time, it will be a futile exercise to arrange an appointment, and on that date, the appointment becomes a futility. It must also be appreciated that infrastructurally, if I could, if I had the power, I would say let us do it at the municipal council, if I could. But magistrates' courts in particular, they hold court at places that are proclaimed, and this is the only court that is proclaimed, unfortunately. So that is the difficulty that I am sitting with. I am able and willing, but the effect of the matter is if we do this, someone is always going to complain. Those that have been given an expectation that their cases will be heard on those specific days that have been set for example, for the 8th of November. I take a valid criticism that you raise against the prosecution that they are not available. But again, just as it's a sauce for the goose is sauce for the gander. Just as your counsel and yourself will not be available on certain days, so we must also apply the same principle to the prosecution. Again, my hero, Justice Krechler, fairness is a double-edged sword that cuts both ways. I must be fair to you, the defense. I must be fair to the prosecution. So the constitutional right, it is kept in mind, but the earliest available date, minus all the hiccups, it was the 15th and the 18th. The 15th is totally open, but the 15th is a regional court, so we will not be utilizing this court. The 18th is the most suitable one. Let us not drag this matter further, please. I'm not saying you are unreasonable, because you are not, but I still have to hear something much more pressing than was from your colleague.
I do understand you. So may I suggest actually that the court first hear this, because if this matter can't proceed as I've been hearing it might not, then obviously there's also a date that needs to be arranged there so that we can see what we're doing with all the dates.
Perhaps we can do both of them on the same date.
That's what I'm saying.
Yes, but let us not put the cart before the horse. Let me hear Mr. Van Heerde.
Thank you, Your Worship. Your Worship, I hear about the problem and as far as the logistics is
And
concerned.
let's keep in mind, as we are arguing this semantics, time is moving.
As far as the logistics is concerned, is there no ways that this matter can be transferred to one of the other courts in this area?
This is the only court.
It cannot be transferred to the Cullinan court.
Cullinan is a different district altogether. We'll have to. No, I cannot. I cannot say. It will be a very good reason for a review to set aside the proceedings.
Well, we must try to get something somewhere.
That is why I have already mentioned the point that, unlike the High Court, which has that latitude, a magistrate's court must hold a court at a place that is proclaimed to be the place of holding a court.
Your Worship, yeah, the problem is that it's a serious infringement as far as the constitutional rights of accused number 9 is concerned, and she's severely being prejudiced as a result of this. But and unfortunately, we started at a very, very late stage this morning. And I understand that we were sitting and there were other accused that also we had to deal with their bail applications, and they also have a constitutional right and to have it heard as soon as possible. But under the circumstances, there's no ways that we'll be able to proceed now with her bail application. We're not going to finalize it. Unfortunately, we will have to postpone. But and it would appear that the 15th is then the only possible date for us to deal with the matter.
So it appears. Let's hear the prosecution.
My colleague just mentioned the 15th. I thought this court referred to the 18th.
No, I said the 15th is open in the diary, and the 18th is also open. So those are the 2 dates. But I have said on the 15th there would be this regional court sitting and holding court.
May I suggest, Your Worship, taking into consideration, and I do agree with my colleague on behalf of accused number 9, it's going to take quite some time if we're going to start with accused number 9. Maybe we must reserve then the 15th as well as the 18th, both of those days. And if we do not finalize both on the 15th, at least we do have the 18th to continue.
You are a resident prosecutor here. You know better than I do. And I would ask you to guide us. From what the head of office has informed me, the court room that we are sitting in now on Fridays is the regional court.
Your Worship, how it actually works, the regional court sits every second week. So this week the regional court is sitting in Cullinan. Next week the regional court is sitting here again, and then we're going to have that problem. And the same with the 18th.
Okay,
the 18th,
so next week the regional court will be sitting here.
Yes, Your Worship. That is
so that week will not be. Then the 15th is available.
The 15th is available, Your Worship. On the Friday, the regional court is not sitting that week, but the regional court
then
is.
Then we have a date.
As it pleases the court.
Mr. Van Heerde.
Thank you, Worship. Your Worship, I will suggest let's stick to the 15th, and on the 15th we see how far we get, and then we will deal with the matter. If we cannot finalize the matter on that day, we can arrange a further date on that stage. Then we know where we stand.
Yeah.
At this point of time, we think that we may not be be able to finish the matter on the 15th, but there's a likelihood that we will be able to do so. And let's rather than stick to the 15th.
I'm sorry again, Your Worship. My suggestion will be let's keep the 15th open for accused number 9, and the 18th for accused number 1. Then we can ensure if, that we do number 9 on the 15th. I can make an arrangement with the regional court magistrate again, as we did last week. The court will remember last week and Thursday the regional court was also sitting, and the regional court magistrate could accommodate us because he's, for the lack of a better word, his role fell flat. I cannot anticipate what's going to happen on the 18th. The regional court is sitting, but if we have ample time, Your Worship, maybe there's a matter or so that we can cancel the witnesses because we do have enough time, or make some arrangements so that we can ensure that one of the two courts is available for this specific matter. So my suggestion will be 15 November for number 9 and 18 November for number 1, as it pleases the court.
Sometimes we anticipate things to go long and they fall flat. Sometimes it is the opposite. We'll take the 15. We'll see how far we go.
As it
and
pleases
if
the court.
needs be, then we'll crowd it out to the next date. Mr. Venter?
Yes, Your Worship, I prefer that we keep both dates together then, for 1 and 9.
You wanted to address something?
Yes, Your Worship, if I may just quickly approach.
Yes.
Thank you, Your Worship. As I said earlier, it's on instructions of my client, just on some of the things that he wants me to record on the record. Since he last week, if I may proceed, Your Worship.
I'm listening.
Thank you, Your Worship. Since he arrived at prison last week, the head of prison, Mr. Smith and Mr. Meyer, already received him there, which is already quite strange. And while they received him there at prison, they received a phone call from the minister, Mr. Groenewald, that apparently told them in my client's presence over the phone that they must make his life hell at prison. Since then, everybody that he was in custody with him got assaulted if they befriended him. The evening that late they came into his cell, they made him strip naked, strip searched him, said, "We know that you've got a phone, you had a phone, you've got a phone." And then they performed the cavity search on my client as well, without any proof that he ever had a phone, which he did not have a phone as well. They couldn't find anything. From there on, they were moving him to different cells, putting him in single cells, which is normally a punishment. Then also moved him to a maximum security cell, as he put it to me, where Radivan Kretcher was held when they were scared he was going to escape. At this stage, there's no grounds or reasons for the prison to treat accused number 1 the way they are treating him, and they are infringing on his constitutional rights of human dignity, plain human dignity at this stage. I believe this is a cause of concern. They are trying to intimidate him and break him mentally, as he puts it. They threaten him all the time as well. The guards, not the other prisoners, it's the guards, threatening that he's going to be assaulted, that they know he's busy with things when he's isolated.
Bring an interdict in the High Court.
We will take it on as well with correctional services, Your Worship. My client just wanted me to place it on record in this court as well, so that this court is aware of it. And we will take the appropriate steps in the High Court as well at this stage.
Because I haven't got the powers as magistrate to issue, in any event, it will have to be a substantive application for the relief that he is seeking. The Magistrates Court Act and the Criminal Procedure, they do not empower me so much in relation to the grievous complaint that he is raising, which is quite serious.
As court pleases, Your Worship. we will do so. Thank you, Your Worship.
That the journalist just remove himself from our face, please. They're intimidating me. It's not acceptable. Johan Abers, please.
Gentlemen, ladies, for what Mr. Liebenberg has said, please remember and keep in mind that although you are given it's not a privilege, the duty to do your job, there are limits to it. Whether what he's saying is true or not, it is not something to be argued now, but as you go about doing your duty, remember that it must not be intrusive and invasive to the right to privacy. If a substantive application is brought in that regard, which the court can hear, you will be handicapped because you will not even have counsel to argue on your behalf. I trust this is sufficient. Thank you. You may now stand. The matter is postponed until the 15th of November 2024. It will be for bail application for both of you. You are currently in custody. It remains the position until bail has been had and the determination by the court has been made. You understand? As for the concerns that your lawyer has made, you've heard what I've said. I haven't got the power to issue an interdict against a government department, but the High Court has got that power, and I trust your lawyer will do the necessary in that regard. Very well, you are then excused. For the legal team, and you may sit, for the prosecution as well as for the defense. We started a little late today. There were good reasons for that. I would hope that when we start next time, all the difficulties that we encountered, which caused us to start at the time that we started, have been cleared up so that we have more time available for the application.
Your Worship, I do concur with the court sentiment. I would like to mention that, I am in possession of accused number 9's statement. I trust that accused number 1 will bring his, or I will be placed in position of his statement timelessly. So to assist the court so that we can start hopefully just after 9, 9:15, 9:30, whenever. It's not necessary for us to read through all the statements which happened this morning. But I do take cognizance of the court's request and will ensure that we start on time on the 15th.
Let me put it this way, Mr. Conradi, Mr. Van Heerden, Mr. Venter. This application, bail application, is brought in terms of Section 60 of the Criminal Procedure. That does not put an obligation on you to favor them with such statements. But in terms of Rule 55 of the Magistrates Court, you always have to do that. But we are not dealing with that. We are not acting within that ambit. So, but let us keep this in mind, and for the benefit of everyone, to facilitate the smooth sailing of the application so that we do not. Thank you. Is that the role?
Thank you, Your Worship. That's the role for today. Sergeant, just take me out, please.
The accused are excused. The court is still in session, please. Thank you. The court adjourns.